Hello, my name is Eric Willison. I am an attorney. I am certified to practice law in the state of Ohio. It's important to note that I'm only certified to practice law in the state of Ohio. If you're watching this video and you're in a different state, then your laws may be different. As an Ohio attorney, I wouldn't know what your laws are in Alabama or Arkansas or Alaska. So if you are an Ohio landlord or tenant, then the information here will be relevant to you. Also, please note that it is information. This is not legal advice. That's because while I am an attorney, I am not your attorney. That's because I've never met you. I don't know any of the facts about your situation. And as such, I cannot give you legal advice and am not giving you legal advice. What I'm providing you today is information, primarily about the eviction process and defenses to evictions that tenants might have. In previous videos, we've talked about the three types of defenses that a tenant may have. One would be factual or merit-based. One would be legal. Another would be procedural. And sometimes there's a little bit of blend between those three or two of the three. Today we're going to talk about what's called an equitable defense to evictions. And that is called the unclean hands defense. What can happen is that if the tenant can show that somehow the landlord is responsible for the tenant not being able to comply with the lease agreement, then that can be a defense to the eviction. And that's because evictions are equitable remedies that the court has. Now, to briefly address what that's all about, courts have two powers in Ohio. They have legal power, which is the ability to make sure that the plaintiff gets a monetary award if deserved, or if it's the defendant counterclaiming, whoever is bringing the lawsuit or the cause of action can recover, using the court's legal power, can recover money from the other side. Get a judgment for $5,000, get a judgment for $50, whatever it is. However, the courts also have what's called equitable power. We're talking about the civil courts here. The courts also have equitable power, and the equitable power is the ability of the court to tell someone to do something and to put them in jail for not doing it. That's contempt of court. But whenever a court orders somebody to do or not to do a thing, that is an example of a court's equitable power. So for instance, if there is a strike out at the gates of the factory and the factory owner says to the court, these employees of mine who are striking are standing in the midst of the opening of the gate to my factory and prohibiting the supply trucks to come in and drop off whatever supplies they need, whether it be coal or if it's an animal processing plant, the animals to be processed or whatever. If they are standing in the way of the ingress and egress from the plant, then the owner of the plant may go to the court and ask for what's called an injunction, saying to the striking workers, it would be the court saying to the striking workers, you cannot picket within 100 feet or 100 yards, or you cannot block egress and ingress. And if you do so, then you're going to have to come to the court and you're going to have to explain why the court should not put you in jail for contempt of court. Now, an eviction, because the landlord is trying to get the tenant out and is trying to get the court to order the tenant to leave, it's an equitable action. Now, the way it works in Ohio, of course, is you don't get held in contempt of court if you don't leave, but the bailiff of the court will come out and force you to leave, and if you don't leave, then the bailiff will call the local sheriff's department, and the sheriff's department will send you off on your way or arrest you for trespassing if you don't. There's a video on this channel about the process of an eviction, That happens at the very end. But again, evictions are equitable actions. The reason that that's important, there's that distinction between legal and equitable actions, is that there are certain defenses to equitable actions that are not necessarily there for legal actions. And one of those defenses is the defense of unclean hands on the part of the plaintiff. They don't literally mean that your hands are dirty with grime because you've been working on an engine. What they mean is that there is some aspect of the landlord's conduct that has caused this whole thing to blow up in the first place. So for an example of this that comes from case law out of the 10th District Court of Appeals, there's a case called Zanetos versus Sparks Realty, or it could be Sparks Realty versus Zanetos, I forget which, probably the latter. But what had happened was Mr. Zanetos was a tenant at a apartment, and it was owned by the landlord, and the landlord then sold the property to Zanetos, that Zanetos was occupying, sold that property to Sparks Realty. Now, the problem, of course, was that no one told the tenant about the transfer of ownership. So, the time to pay the rent came along, and Mr. Zanetos tried to pay the rent to the old landlord. And in the intervening 5, 6, 7, 8 days of confusion, the new owner, who probably bought it in order to get rid of the tenant and do something else and wanted the tenant out anyway, seized upon the fact that the tenant had not paid rent right on time as required by the lease, and brought an eviction action against the tenant. Now, the case went in front of the court, and the tenant said, look, the landlord, the old landlord and the new landlord caused this problem because they never told me that the place had been sold. And I just naturally went along and tried to pay the old landlord. So I am not the cause of not paying the rent on time. I stood ready to pay the rent. I just paid the wrong person because they didn't tell me any different. And so the Court of Appeals, the 10th District Court of Appeals, ruled that it was proper to allow the tenant to stay at the premises because the landlord, both the old landlord and the new landlord, didn't inform the tenant that he or she had to pay the rent to the new landlord. So that would be an example of how the landlord's actions or inactions have caused the problem that the evicting party is relying upon in order to get the eviction. Another way that this might manifest itself, perhaps the lease agreement says no dogs at the premises, but then the tenant happens to have a conversation with the landlord. The landlord likes dogs and makes a statement to the effect of, yeah, I know there's a no dog thing in your lease, but I don't really care if you get a dog. If you get a dog, that's fine with me. Or maybe he texts that, or maybe he emails that to the tenant. And then later on, the landlord changes his mind about the tenant, or changes his mind about the dog, and says, oh, you've got a dog, and the lease says no dogs, and so I'm going to evict you. You could point out that under equity, the landlord would have unclean hands here because the landlord is the cause of the problem that he complains about. Now, one of the things that the landlord's attorney is going to argue in that case is he's going to argue something called the parole evidence rule. That's P-A-R-O-L, parole evidence. And what that says is that normally, if you have a written contract and the contract contains the terms of the agreement, then any other side agreements or oral statements or unsigned writings going back and forth cannot be used as evidence to prove the terms of the agreement. So the landlord's attorney is going to say, Your Honor, I'm going to object to this testimony about what my client, the landlord, said about it's okay to have a dog. Under the parallel evidence rule, that can't come into evidence. And the tenant or the tenant's attorney would counter-argue, I'm not trying to prove the terms of the lease agreement. What I'm trying to do is prove the affirmative defense of unclean hands. And those are two different things. So we're not using the landlord's statement against the landlord for the purposes of what the lease says or doesn't say. We're using the landlord's statement to prove the affirmative defense. And I think that argument wins. In which case, the judge is going to lean in and say to the landlord, case dismissed. So be careful about how you conduct yourself with your tenants. If you do something that makes it so that they can't pay rent on time, maybe you go on vacation on June 25th and don't come back until July 15th, and then you say, oh, well, the tenant didn't pay me the rent, and the arrangement has been, let's say in the lease agreement, that the landlord will stop by the tenant's house and will pick up the rent on the third day of each month. And then you didn't do that. Well, that's your conduct is what caused the eviction. So make sure that your conduct is not a cause of the problem that you are now complaining of, or you face the possibility that your eviction will be dismissed.